Welcome to the Case Autopsy, the Verdict and Settlement podcast with your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your hosts, Mike Campbell and Chris Finney.
Hey man, we're back again. We are knocking out a few podcasts in between trials, and we're being a little bit more consistent about it. So that's great.
I think we're kind of finding a rhythm, and it also helps when we're getting top people on to kind of pick their brain, top real trial lawyers. And that's who we got today, which is
Chris Nace is one of the best, the best.
Read his name a lot, seen a lot of his results on a lot of the national listservs. And I'm very interested to talk to him about his practice, how he developed some of these strategies and things like that, because it's mostly med mal. And that's, as everybody knows, that's a lot of work.
A lot of work. And I think we just get right to him. Without further ado, Chris Nace.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Hey, welcome everyone. Today, Chris Nace is joining us. Chris, how are you?
I'm doing okay. How are you guys doing today?
Good. Hey, why don't you tell the listeners a little bit about your practice and what kind of work you do?
Sure. So I work with my dad and my brother. We have a small firm in the Washington, D.C. area. We do mostly medical malpractice, other catastrophic injury, wrongful death stuff. Firm is Paulson and Nace, practice in DC, Maryland, West Virginia, doing a little bit in Florida too now. And we do mostly single event injury cases and try a lot of them. And you know, that's the fun part. We get to go to trial and try a lot of these cases.
Chris, one of the things you mentioned was you do, medical malpractice in the DC and West Virginia. I think the case we're going to discuss was in West Virginia. How did you end up doing medical malpractice cases?
Well, my dad's been doing it for over 40 years, and I joined his firm, I guess in 2007. And that is the bulk of what we've been doing. I was doing patent litigation at a great firm before that, was really happy, but I wasn't going to see the inside of a courtroom too often. And that's what I went to law school, was to try cases and to do that. And so I left the patent firm I was at, had a lot of good training, a lot of good experiences there. But this is getting me into the courtroom a little more and has for the last, 14 years now.
How was that learning curve? I mean, I know that your dad had been doing it for a while, but, jumping into med mal cases, what was that like?
Yeah, I mean, your head's spinning a little bit. Doing patent work was similar in the sense that you sort of have to learn an area outside the law that you don't really have any business learning, right? Like, when you're doing patent, you're learning some piece of technology and you have to just figure it out and learn it. And med mal's kind of the same. You go in and you figure out a particular area of medicine and what the standard of care is, and what the results can be if it's breached, and you just educate yourself and learn about it. And so there was a little overlap there, but the trial stuff is really the hardest. And I think what clicked very early for me was doing medical malpractice and really almost any kind of plaintiff's work. Boy, you have to be darn near perfect every time. I mean, the margin for error is really, really thin on these cases as a plaintiff. And so that was probably the biggest slap in the face, is that whenever you open your mouth, whether it's a deposition, a hearing, or a trial, you better be ready to be perfect or darn close to it.
And so just kind of a personal question here, but that's pretty stressful, right? Because you got a lot going on. What do you, how do you deal with that? As a guy who's tried many of these cases, just got a great result in West Virginia. How do you deal with that? Or how did you learn to deal with it?
Well, I think, preparation, right? I mean, you got to just know everything and know the record, know what your experts are going to say, prepare them, work with the medical literature. I mean, the more you work on it, the more confidence you're going to have when you step into the courtroom. So, you hear it from a lot of great trial lawyers, and that's where I learned it, from watching some of the greats and listening to seminars and podcasts like this. You just got to prepare and prepare and prepare. And the more you do that, the more confident you feel. I mean, it does bring your stress level down if you think you know your case and know the file.
Yeah, absolutely. And one of the cases involved a medical malpractice suit in West Virginia, and that was a multi-week case. And could you tell us a little bit about the facts as far as you can, and then what the case was about?
Yeah, I mean, this was a birth injury case. It was it's an interesting case in the sense that it's a hybrid where the United States is a defendant in the case because a clinic gets federal funding. And we see this in a lot of our cases in West Virginia. There's a lot of clinics that are funded by the federal government. So there's a Federal Tort Claims Act aspect to the case. But we also had a private hospital involved in the case. Really, the allegations were just a complete failure to monitor a delivery. Our client, Crystal Heisel's mom, went in to deliver her baby, and it was, the date of the delivery was October 29th. And so she went into the hospital October 29th of 2010, and at some point, the fetal monitoring strips just become completely worthless. And the labor and delivery nurse who's there attending to her is really supposed to be able to interpret and understand what's happening with those strips, at least have a basic knowledge that the electrodes are on correctly and that the strips are actually recording valuable information and presenting it. And so there was an allegation against the nurse. That's why the private hospital was in the case. There was also the midwife, who was the agent of the federal government, who didn't show up really until about 4 minutes before the baby was delivered. And so there was this allegation that there was just a complete failure to monitor for about 2.5 hours or so before the delivery. In addition to that, post-delivery, it was a strange set of facts. There's like a time period in the labor and delivery suite where it seems like everybody's assumes everything's okay, even though the APGARs are low. The parents testify that the baby wasn't reacting, wasn't moving, that there was some blueness in the limbs of the baby. And then this part that's strange, and we never got an answer to this, is at some point a nurse hands the baby to a nurse that was walking by in the hallway and says, get her to the nursery or something like that. I mean, it's really unclear. We had these nurses testify. None of them remember why the baby was just handed over. And then the baby was taken to the nursery where her SaO2s were at 68%. And this is about roughly 13 minutes post-delivery. The SaO2 should be higher than that. We had good testimony from everybody in the case that was low. Some of the experts for the defense tried to dispute it, but really that was too low. They had to do some oxygen, supplemental oxygen, and some suctioning in the nursery. But there was a 4-hour period where mom never had her baby. And the hospital actually had a policy in place that you should start breastfeeding as soon as possible. So this sort of black hole window of what was happening, we never really got an answer to that. Nobody's ever really said what was going on. But that's a sort of a thumbnail sketch of the case is it was just a failure to monitor. And at the end of the day, the child ended up with a hypoxic brain injury that led to a diagnosis of cerebral palsy.
And were you, Chris, when you said it was an FTCA case with a private defendant as well, are you in the Court of Federal Claims?
No, the case was tried in the Southern District of West Virginia. So we had a jury trial, and what the judge did was, and I forget the rule number now, but there is a rule on this. I should have looked it up before we started, but there's a rule that allows the judge to take, I guess, what he calls an advisory opinion. So honestly, at this point, we don't have a judgment or a verdict against the United States, but we do have what the jury did, and of course, this is all public record. The jury did put 70% of the fault on the private hospital and 30% on the United States. Now, what the judge does with that is up to him, and we're waiting his ruling. There's been briefing and facts submitted and orders submitted and all that sort of stuff. And so we've just wrapped up all the briefing at this point. The judge could take the jury's verdict. The judge could throw out the jury verdict as to the USA or whatever. But so it was interesting because the jury didn't know that ultimately their verdict as to the USA would not be binding.
So that's pretty, I mean, I don't think I've ever heard of that actually. So as for our listeners who don't know, on the Court of Federal Claims cases, the judge actually would, it's not a jury trial. The judge would decide that, and those cases are essentially bench trials. But in this case, interesting, there's a rule that they had the jury trial and the judge, you're, I guess, anticipating that he'll assess 30% of the damages against the United States based on what the jury did, but he can do whatever the heck he wants.
Yeah, he could. That's right. Listen, I'd be a little surprised. I mean, we had a good jury, and the judge was, he praised the jury after their verdict on the record. So, it'd be a little strange if he did something different, but certainly well within his right. And, we've done all the briefing on that. So, fingers crossed.
Yeah, that is a very unique procedural plot. That's interesting.
Well, and think about it this way too. I mean, to make it more interesting, the damages are the damages that the jury's awarded, right? The jury found by a preponderance of the evidence that the damages were $10.8 million. Okay. Now, what if the judge comes back and says, well, I don't think the USA is responsible for anything? That private hospital just got hit with another 30% of 10.8 that as of right now, they're not on the hook for.
Is that how
I don't think you can overturn that.
Yeah, he can't diminish the total damage amount. Someone's got to pay it, right?
It's got to be 100%. So if you look at the verdict form and the verdict form puts 70% and 30%, that's got to get to 100. So if the judge just takes the 30% and puts 0, the rest of it goes on the private hospital. So it's an interesting little bit of exposure for them right now.
Was there on your guys' post-trial briefs on that? I guess they weren't really post-trial. They'd still be submissions on that 30%. Did the hospital place blame on or
No.
whoever they did not try and play that angle? Yeah.
They did not.
Interesting.
So it's interesting. I mean, it is an interesting little twist. And like I said, we're still waiting to see what happens. My mom always said that big verdicts feed the ego and settlements feed the family. So, we're sitting here talking about this case, and it was a great result.
Anything.
Yeah, that's right. It's but we're in that precarious situation where you never know what's going to actually happen.
So, in terms of your proof in that case, obviously you have a life care plan. And I'm always curious with this. I asked the other week we did the last one. I asked on that too. You using medical doctors, nurses? What are you using for your life care plan?
Yeah. So in this case, we had a pediatric neuropsychologist who evaluated the child, and then and his name was Thomas Regino. And Dr. Regino examined the child, spent some time. He's really, really fascinating and fantastic. And one of the disappointments, so this was obviously conducted, in the midst of COVID. We can't really say post-COVID. Dr. Regino testified remotely, and one of the disappointing parts of that is that I've seen him in trial with a child, and he comes off the witness stand and interacts with the child, and it's really pretty breathtaking. He's a good witness, but he worked together with a life care planner, Laura Lampton. And she and him, they came up with the life care plan. She drafted the plan based on his recommendations. So she's a nurse.
Okay. Gotcha. All right. So they obviously had to get some doctor or based on the records or get some doctors to sign off on some things, or how did that?
Yeah, well, that was what Dr. Regino did. I mean, that was why he spent the time doing all the neuropsych evaluations that he would of a child. And I think, he testified, I think that he spent 3.5 hours with the child in addition to reviewing of all the records.
Gotcha.
One of the interesting and tricky parts of the case, and, something that actually, I think we handled pretty well given the circumstances. this baby at about 16 months, the family was looking for answers as far as why she wasn't hitting developmental, milestones and goals. And an MRI was conducted that, unrelated to the negligence in this case, was misread, and nobody really disagreed with that. But the MRI did show brain damage, but in reading it at the time, they said there was no brain damage. Okay, so now the parents go on a quest for what's happening. Why is our daughter not, hitting these goals? So at some point, the baby gets a diagnosis of autism. Well, fast forward like 5 years, and a doctor at Cincinnati Children's Hospital is evaluating her and says, this doesn't seem like autism to me. So he goes back and does another MRI and says, look, there's brain damage right there. He goes back, gets the original studies and films, and says, yeah, it was there all along.
Wow.
But now we had autism in the record for 5 years. And even our expert, Dr. Regino, he thought there was definitely some underlying autism as well. All right, so what do you do with that? I mean, it's a big part.
It's a sandwich right now, it sounds like. I mean, you got people going all over the place now. We're going to retrace what we've been doing for 5 years, but there still is some of this here, and whoops.
Well, and from the damages and the life care plan standpoint, how do you convince a jury? Yeah, that's right. So we just sort of went with it. We brought it up in opening statements. We talked about autism, with our experts, with their experts, and the damages from your typical motor control issues that go along with cerebral palsy are very different from what you would see in autism. And basically what we did was we spent a lot of time with our life care plan tables that we put in evidence, and with the economic report that reduced it to present value. We tried really hard to teach the jury how to use the tables, that if they wanted to take something out of it because they felt it was more likely related to autism, they could do that. Wow. And we showed them with the experts, if you want to subtract this, this is how you do it. We had all our damages sort of broken down into chunks, so that if they said, okay, our experts said that, speech and language therapy probably was not from CP, was probably from autism. And that was in the life care plan for a host of reasons. We taught the jury how to take it out. And so we wanted them to feel like this was their decision, right? We gave them on lost wages, that was a claim. We had a bunch of different scenarios, with minimum wage work to average work for a high school graduate. And we taught the jury how to pick those items from the life care plan, from the wage report. We taught them about life expectancy. And we gave them all this information and said to them, look, you heard about autism. Do we really think this child has it? No, we don't. But yeah, it's probably in the case and probably something you have to consider. And we went to great lengths to empower them to make the decision of what they thought was part of the CP and what might have been there anyway. And I think that helped us with our credibility.
So was this the first child for these parents?
Yes.
So they really didn't know in the delivery room what's normal, what's not normal. They're just kind of bystanders. They're taking it for the first time as well.
Yeah, that's right. And we use that to our advantage also, because they were great. I mean, they were great clients. The father's a minister. They were incredibly believable. And they're just wonderful people. They're not misleading anybody. They're just doing the best they can. But I cross-examined one of their experts, and I said to him, you have kids, right, doctor? And he said, yeah. I said, you were there for their deliveries, right? Yes. And I said, those moments are seared on the front of your brain, aren't they? Those moments in the delivery suite when your children are born, that's seared there, that you don't forget those moments, do you? And he said, no, those are moments you never forget, though. You could picture it like it's yesterday. Well, when our parents were testifying about how positive they were about things that happened, there was an issue of the midwife saying the cord was, in the way and blocking the baby, and she had to push the baby back up. And the parents are testifying about hearing this stuff. The jury's sitting there, and the defense expert had just said, yeah, you don't forget what happens in the delivery suite when your kids are born. So, I thought that was,
Yeah. Are
that was
there, and
compelling.
so that's really interesting, actually, the way you layered that in with the jury. And especially now I'm thinking your multi-week trial, but on top of it, give us a little background on West Virginia. Caps on damages. What's the deal out
Yeah,
there?
there's a cap. There's a 2-layered cap. I think the defense moved for to reduce the verdict to just what the higher cap is. It goes up by CPI, so it's a strange number. It's like right around 750,000. So the jury awarded $1 million on pain and suffering and non-economic, and that will be reduced in accordance with the cap.
The rest is
economic. And that was, that's a tricky thing too, right? When you're talking to the jury,
how do you balance?
We said in closing, look, ladies and gentlemen, and it was actually ladies and gentlemen. We had 7 women and one guy on the jury, and we said, look, you award what pain and suffering you think is appropriate, but this trial is about taking care of this child. That's why we're here, and that's when we focused on the economic loss numbers on the verdict form in closing argument. And we really wanted to make them understand that this verdict was to take care of the child. We weren't looking for sympathy. They weren't looking for pain and suffering. And I think they responded well. I mean, look, they could have put a big number down on that non-economic line and nothing down on the other lines, and it would have been very problematic.
Yeah.
To say the least.
We're 2-week trial or 3-week?
It went into a 3rd week. It was about, I guess it was 2 days into the 3rd week.
What is your, I'm thinking more now towards you and your support staff, mentally, physically, you're living out of a hotel or do you rent a house? What's the deal? How are you staying sharp? What are you doing to get your mind relaxed? How are you staying healthy? You're there for 3 weeks. You may be going home on the weekends. I don't know. Like, talk us through your scheduling for that.
Yeah, no, we were there in Beckley, West Virginia for 3 weeks straight. We drove up on, I guess, the Sunday before Monday. We had a settlement conference and a pretrial, and then started jury selection on Tuesday. And honestly, it's kind of a enjoyable situation in some ways, right? You're just locked. Being in the hotel, makes it, you're just focused, right? I mean, we'd get back from court at 5:30 every day and just go right and have dinner and then go back and work. And for me personally, I was asleep by 9 and up at 4. That was kind of my thing. And then I'd work from 4 to 6, and 6 o'clock I'd go outside and work out and do something, even if I just put music on and walked, for 45 minutes, just something to get out and move around a little bit. And so that was kind of and then the weekends, we actually had Memorial Day weekend in between. So we had a 3-day weekend where we were just sitting in the hotel and really had like 2 more witnesses and closing argument to do, which was nice because that gave a little bit of a chance to kind of get caught up on other things that were going on, in work. So, I don't know. I don't want to say it was relaxing because that's not true, but you really do get locked in and you just get locked in and focused.
It's like training camp. Like I think I saw your brother played football or something in baseball. It's like, in August when they bring you in, they put you in the dorms and they're like, hey, this is all you got to worry about. And you actually get a lot done because it is all you have to worry about.
Yeah, that's right. And it was nice, look, I got to try a lot of cases with my dad. But it had been a while. I hadn't sat second chair in a trial in quite some time. So I was a little kind of discombobulated going in. But we broke up all the witnesses. So I was doing plenty of work on it. But I got to spend, over 2 weeks, close to 3 weeks. We had just about every meal together and we went through this trial. And, I said, my dad's been doing it for 40 some years. And I think this was one of his biggest malpractice verdicts that he's had. He's had some big verdicts. So that's something that was pretty cool. And I'm glad I got that opportunity.
Did you have like tech people there, support staff? Is there just you two? How are you doing it in the courtroom?
We brought one person from the office on the first week, a different person the second week, and then for the third week it was just the two of us. And I mean, it's pretty low budget show, right? I mean, we used a trial presentation software to put up exhibits. And
you trial pad, or what'd you use for that?
We used Exhibit View, actually. Okay. It was the first time we'd used it. and it was great. I mean, it worked great for us. The courtroom was really decked out too with, pretty high tech. Everybody
Helps a
had
lot, doesn't it?
monitors. Yeah, the witnesses could draw on the screen and circle things. The only bad part about the tech was the federal court uses like Cisco, and they won't allow screen sharing outside the courtroom. So all the remote witnesses were not able to see what the jury was seeing. Now, you had to make sure they had the exhibits ahead of time, but they couldn't see what was on the screen.
That was probably a little bit difficult with your doctor, especially it sounds like he was a guy that was very hands-on in all of his other trials.
Yeah. And, I mean, at the time that we were getting the case lined up, we didn't know what was going to be going on. We lined up half our witnesses to testify remote and half came in, and, you do the best you can. We didn't know what the rules were going to be as we were, you got to line those witnesses up pretty far in advance. And so we weren't super sure about what the scenario was going to be when we got there. It all worked out though. I mean, it was pretty seamless. We had a couple problems with tech, and it was really the courtroom. It wasn't on any of the parties. So that was good because, it was the court's issue, not ours. But one lesson learned though, and maybe, people may know this anyway, maybe I'm the guy who was slow on the uptake here, but if you're going to have a witness testify remote like that, I would send him or her to a court reporting facility. I wouldn't let them do it from their home or their office even. They say, oh, I got good internet, I've got good camera. You know what? Send them somewhere that they're going to control, that there's going to be a tech person to control the sound, to control the, where the camera's zoomed in on. That was one thing I would have done differently.
Yeah.
And it was a lesson learned for sure.
What was the masking situation there? Were you guys required to be masked? Could you unmask when you were speaking to the jury? What was the setup? What the judge have decided, or that circuit, that district?
Yeah, they had the courtroom. The jurors were spread out a little bit, and everybody was wearing masks. They had plexiglass around the judge, around the witness. The lawyers were tethered to the podium, which is,
standard for
those, it's a little strange. At least where I usually practice, you can, that wouldn't be the situation. But you could take your mask off if you were questioning or being questioned, and that was really it. And then we used headsets for bench conferences, which I kind of liked. I wouldn't mind seeing that moving forward. The judge would put white noise on in the courtroom, and we would all put headsets on and
at
do
your
our
table?
bench. Yeah, at the table or at the podium, and just stand there and make your argument that way.
That's a great idea.
Yeah, I thought it was great.
Don't have to huddle up on everybody and come up there and get on top of each other, and somebody can't hear and like, hey, get out of my way.
Exactly.
Yeah,
exactly. So and so I thought I would like to see that continue moving forward. I don't know if it will.
Interesting.
It's there's a lot of similarities. You're talking about first you and Chris Finney and Chris Nace should get together and try a case somewhere. Chris wakes up at like 4 a.m. and is out jogging. I'm snoring, I'm like, I'm sleeping in until like 6, the absolute latest I possibly can. And Chris is out the door to the courthouse.
It's easier. I think it's better to get your sleep and get up early than the opposite. But I mean, to each their own. But it's just kind of, I want to go to bed and get up with the energy than the opposite.
Yeah, that's right. That was my approach. But yeah, like you said, whatever works,
So was your, I assume your dad, it was you and your dad that tried the case. You were the two attorneys who tried the case.
Yeah.
And going in, what was the decision in terms of who was handling jury selection, opening? You smiled. Why? I got no.
Well, I hadn't worked too much on the case going into the trial. I kind of got recruited and pulled into it, a couple weeks before. So it was really his case. He had worked it up with my brother Matt, who works with us also, and I got drafted to go and try it with him. My dad was exceptional in this case, but he's 76. His health isn't the greatest. And I sort of, if he listens to this, he'll probably, want to smack me around a little bit. But I kind of had a thought that there was going to get to a point where there was going to be more witnesses that I needed to do than he planned going in. So I was prepared for all of them. Okay. And the the division of work shifted as the trial went on. In fact, he was dealing with a little bit of a infection in his foot, and we were stopping. This is funny. We were stopping at the hospital that was the defendant in the case Monday, Wednesday, and Friday mornings, and he was going in and getting his foot rewrapped and bandaged up, and then we were going to court and trying the case again.
Perfect.
But
Perfect.
yeah, so I think at the end of the day, I mean, I guess he probably did more of the experts on our side of the case, but it was pretty close to 50-50, you know, at the end of the day on the cross. I mean, there was 19 experts who testified in this trial, because, you know, you had two defendants and they had different specialties, but you know, they also had some overlapping experts on causation and that sort of stuff. So
yeah, what I was gonna say, it's a great thing to try those cases, especially a case like this in teams. And some people get nervous that they won't be able to pick up that slack. But like you said, you were probably lived, breathed, and ate this case and could do all those witnesses, just like your dad could do all those witnesses too, if you're like, I'm exhausted.
yeah, and you know, I mean, it was a lot of witnesses, but the issues were, you know, there weren't too many issues in the case. And you know, I know this is like one of those topics that if you drop it on a listserv, you can like really watch the listserv blow up, but we don't depose defense experts in malpractice cases. That's our practices. We don't depose them. So we were crossing them based on their report. And
but let's put a pin in that one, because I like these strategy type talks, especially when you're doing stuff that's kind of outside the box. Like in Oregon and stuff, you don't really know who some of these people are, but here you knew, and you guys make a strategy decision. We're not gonna do this. Why? Is that just the way your dad's always done it, or you kind of like, I like this. This is save money for sure, but
yeah, you know, it's probably been about 10 years of doing it. But you know, we used to depose these guys, and you know, guess what they say? Oh, the doctors did everything right. You know, newsflash, right? I mean, look, if there's some strange causation issues, we may take a deposition or something like that. Gotcha. But for the most part, it's been our experience that you end up teaching them about the case. You know, they're not prepared, and if you depose them, they get a sense of where you're going. They read their depth. They start studying a little more. So you know, and look, you read those reports. There's some good stuff in there, and I know that we always say don't ask a question you don't know the answer to, right? But sometimes when you're trying these things, you got to take a chance. I mean, there was a doctor who, throughout his qualifications, they talked about how much editing he did of medical journals, right, to build up his qualifications. And when I crossed him, I said, I made a point of that. You read journal articles, you pay attention to the writing, you edit these things, right? You know words matter. Yep, sure do. And you know, then I asked him, so when you wrote in your report that there was no significant hypoxic event, you put that word significant in there because you agree there was a hypoxic event that happened, right? And he said yes. And you know, it's a little bit of a risky question. I mean, he could have said no. I just
but you're right. I mean, it's like, don't ask a question you don't know the answer to. But you can ask questions where the only answers are pretty crappy for them. Like there's no way he's got a chance to wiggle. Anything he says other than you're right looks bad for him. Like
that's right.
You kind of painted him into a corner on those.
Yeah, that's right.
And then he can't clean it up by trial time or amend his report and say, I meant that was a typo or something or blah, 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 and it's fixed. And then some judge says you can't get into it because it's totally irrelevant at this point.
Right.
In terms of just, opening the case and giving your opening statement, you've got a 2.5 week trial coming up. You know, folks, this is what you're going to hear. What was your opening statement like? Who gave it? And, you know, what did it cover?
Time limitation too. Is this judge giving you 20, 30 minutes? What's the deal?
15 minutes. Which was pretty tight. My dad did the opening. And you know, one of the things that he's always been great at is just talking to juries. You know, this is what the case is about. We had the child in the courtroom during voir dire at the request of the defense, by the way, but not during opening. But he talked. You know, he said, "You met the child the other day," and he just talked about the experts that were going to come in and the issues. And again, we got right into the autism issue, the bad facts of the case, right? I mean, and I say bad facts in quotes because, facts are facts, right? I mean,
Right.
you got to deal with them. Certainly we would have preferred not to have to address autism in this case, but we talked about it right at the beginning and told the jury, this is going to be an issue. They're going to have to decide what damages are related. And, but it was a pretty casual conversation. No PowerPoint, no blow-ups in opening, anything like that. It was just a pretty straightforward, this is why we're here, and this is what you're going to be asked to consider. And, just a chat with the jury.
15 minutes.
Voir dire was not like that. Voir dire was not like that. Voir dire, and partly because of COVID, was the judge asked, about 20 questions.
Mm-hmm.
Jurors wrote down their answers, and then one lawyer side was able to go on questions. And so there wasn't this voir dire that, that you hear about where lawyers get to make a closing argument almost in front of so
there's no group forming in that. You're just kind of, it's very aseptic. You're getting individualized. You don't know who is interacting with who, really, right?
Yeah. And I don't know how this judge would have handled it if it wasn't for COVID. I'm not sure what his practice would have been otherwise, but it is what it is, right? You just got to go with it.
So you do your opening in 15 minutes, which I think Chris and I tried a case about a month ago, and I was kind of getting worried about going under 20 minutes for a 3-day trial. So thank you for emphasizing that we can all shorten those things up a little bit.
Yeah.
Closing, what's going on there? What's your time limitation? Who's doing that?
So closing, I think the judge said 30 minutes at first, and the defense lawyers went kind of like, everybody looked at each other. It's like, you got to give us more than that. And
I can't I think say everybody's name in 30 minutes, Judge.
Yeah, I mean, right, it was 19 experts testified. Yeah. I think we got an hour at the end of the day, and again, I let my dad, didn't let him. I mean, it was his case. He did the, I wanted to do it, of course, but it was his case, and he did the closing. We put up a PowerPoint. One of the fun things that we did, I think, in closing was in rebuttal. When the other side's giving their closing and you're trying to like scramble and write your notes down and figure out, I've only got 12 minutes left to hit all this. So I'm sitting there and I just started making PowerPoint slides. And as they were saying stuff that wasn't accurate or that we could refute, and I started, we had one key witness who testified by video recording. So we had his transcript. So they just blatantly misrepresented something in his testimony. And I was able to go and pull the actual page and line site and put it into a PowerPoint slide. So, we were sitting there and I'm making these slides and my dad's writing his notes, and he looks over at me at one point, he says, "Are you making slides for me to use?" I said, "Yeah, I got your rebuttal here." And he was like, "Oh," and he just sat back and didn't even take another note the rest of the closings. He just got up there and I would hit this next slide and he would be like, look at the slide and be like, right, and make the argument, so we had everything, at every point that they brought up that we wanted to refute, we had a slide ready to go. And I think that was helpful, particularly when you can pull in images from reports or from exhibits and testimony and use that to actually show the jury what they just told you isn't right, and here's the page and line site of what the expert actually said. So that was I think that was effective.
Yeah, totally.
It sounds like, what's interesting, I think, about the way that you guys are going about a case is it's I don't want to say it's spontaneous, but it is. A lot of times where Mike and I try a case, a lot of it's by video deposition, it's been edited. And I got to tell you, in our last trial, we probably spent 20 hours of court time arguing over designations of the video. And it's like, oh my God, this is brutal. I'd rather have the person come live. You just obviate that by not even taking their expert's deposition. So they kind of have to come live.
Yeah.
What we think, it's funny how you put it out there, because what we think is, we do these ahead of time so we don't have to worry about it during the trial, when in reality we spend an enormous amount of time worrying about it until you get fresh on it in the trial like you guys did, and you just kind of pick your points and you just pick them and go, and they don't have time to jump on it. I mean, is that really what you guys are looking to do? Is like, hey, we'll pick a few points, get them and go. No need to get in the weeds with them. Just hit them and go.
Yeah, I mean, that's right. I mean, that's always been my approach. And you know, look, practice is different everywhere across the country, the way some of the use of video deps and stuff goes. But, you know, I don't really want to tussle with a pediatric neuroradiologist for too long if I don't have to. I mean, I think I study and learn the stuff as best I can, but
you didn't go to school for it. You didn't do a residency and a fellowship. Yes.
Yeah, that's right. It's, you know, it's like a boxer. You get in, you throw a couple jabs and get out of there, make your points and get out. I mean, our crosses were not very long of some of these experts, but, you know, another good sort of lesson learned, I guess, for me was don't be afraid of the literature the defense cites, right? Just because they put a pile of literature behind their reports, you know, hey, read it. It might not say what they say it says, right? I mean, like, they made a big deal that our child was full term and you wouldn't see the type of brain injury on the MRI at a full term child that you would see on this one, suggesting that the injury happened sometime earlier during the pregnancy. That was their argument. Well, they had a Dr. Zay testify, who's kind of makes the rounds and does a lot of testifying from Yale, pediatric neuroradiologist, very good teacher. And he testifies for plaintiffs and defendants, by the way. But he came in and he had a PowerPoint presentation that he did. And his presentation said, you do not see this brain injury in a full-term baby. And he cited all this literature. Well, if you read the literature, what the literature actually says is like 65% of the time you don't see this type of brain injury. And so by the end of his cross-examination, you know, he was saying things like, yes, that's what I said, Mr. Nace, 35% of the time, this is exactly what you would expect to see. You know, I mean, a defense lawyer who I know in town called me up after and said, I heard you guys had Dr. Zay testify for you. And I said, well, by the time this cross was over, he was testifying for us. But, you know, I'm not trying to be flip about it, but don't be intimidated by what they give you. I mean, you know, read the literature, go through it, and there may be stuff in there that's great for you. I think that was one of the biggest things about this case. The defense, we can all fall in love with a case, and if you fall in love with your case, that's like the kiss of death, right? And I think, and the defense lawyers were very good, very talented lawyers. They did a great job on their case, and they were generally pretty easy to work with. You know, it was a fairly enjoyable trial to go through, but they fell in love with their case, and this was not a typical result, but it was the result that happened in this case, right? I mean, it didn't play out the typical way that you would think a cerebral palsy delivery or delivery that results in CP would. But when you put the whole case together, you know, remember the burden is what probably happened, and there was no other explanation. So even though it didn't fit probably the way they've defended cases for years, it didn't fit the pattern of what they expected, and so they didn't think we could win. They didn't think we had any chance. But at the end of the day, it really was the most likely outcome. Was the negligence that caused this damage.
That's, I mean, outstanding. And you're trying that case in West Virginia it sounds like a rural area as well, in federal court.
Yeah. It was interesting.
all not good. All things that scare most people, even people who try a lot of cases.
Yeah, it was not, you know, it's not a jurisdiction we typically do case. And we do a lot of cases in West Virginia. This was not an area that we had ever gone into before. But, you know, the jury was great. I mean, they really did. They really focused and paid attention, and they seemed really engaged with all the experts, not just ours. I mean, you know, obviously sitting here having gotten a good result, it's easy to say the jury did a good job, but we felt like we had a shot with this jury from day one. We felt like, you know, this was going to be a fair jury. You know, you pick juries sometimes and you think to yourself, well, will be a fun week of exercise and trying a case. But we felt like we had a fair shot if we could present our case effectively, that they'd give us a fair shot.
You've tried a lot of cases, Chris. I'm sure you've lost some. I don't know. You could be batting a
Yeah.
thousand.
Oh yeah. No, I wish. That'd be nice.
We'd all be attending the Chris Nace seminars if you're batting a thousand on mid-mount.
Right.
You've won some. You've won some very difficult cases as well, especially with this case. Are there some general lessons or some advice you would give to someone out there who might be listening, thinking, "Gosh, I really want to try this case, but I'm not sure if I have it in me to do it."
Well, yeah. I mean, first of all, I think you do. Right. I mean, right away, if you're that close to thinking that I could do this, I want to do it, you do have it in you to do it, and just prepare, just work hard, and then I think, don't oversell your case. Right. If you believe in your case, then fight like hell for it, but don't oversell the points that you can't win on. Develop that credibility with the jury any way you can, even if it's embracing something that you may not think is good for your case. Use that to just build up your credibility with them, because look, we wouldn't be trying these cases if 100% of the facts went your way, right? If it was a slam dunk, then you're not trying it. It's probably going to get resolved. So there's going to be things that don't go your way, and have an explanation for them, but just don't oversell it. Be yourself, and tell the truth, and let the jury know you're telling the truth, even if that means acknowledging something that's a positive for the other side. You just have to do that. Don't run away from things that might scare you in your case. You can embrace them and make them a strength for you.
Outstanding. I'm really, really grateful that you came on the pod to discuss this case, share some tips and techniques and some strategies that I know I am very interested in trying. And we're just really grateful that you took time out to speak with us.
Yeah, thanks for having me. I'm happy to do it. It was fun.
Yep. Until next time.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Man, that guy.
Let's just talk about, there was 19 experts or whatever, and they didn't take any expert depositions, really. I mean, it's just kind of like,
it's fascinating.
It's fascinating. And that is one of the best things about why we do this, is you get to get all different aspects of things. And he kind of jumped into this case like 2 weeks before, whatever it was, with his dad. And, they went to a rural area, and I mean, the ideas they were putting forth, the best thing I think I got from him was you could tell his delivery, the way he's delivering information. It's digestible. He has commanded material. He knows everything about it. It was pretty impressive.
He's an authority and guide on the subject matter.
Yes.
Right?
He's easy to follow too.
I was thinking about some of the things that we've learned from the podcast that I've already applied. So with Matt, we had him on a while back, and him and Lindsay talked about that case where they, were able to keep the defendant off the stand. We took a shot at that in a trial, didn't work out.
Right. We kept rolling. It didn't quite work out. And we had all those elements that Matt Nakajima had lined up. Like, they didn't know anything. They didn't remember anything. They couldn't even see anything. They had no training.
Yeah.
But,
it is what it is. But here's the thing is, you don't know unless you try, and it's a little scary to try. But then when you hear guys out there doing it, it's almost like, it gives you a permission structure to be able to do things.
And hopefully people get that from Chris Nace today, is that they got it from him, that, hey, you can trust yourself, trust you're going to be able to cross these people. And, honestly, how many times have you crossed an expert in a depot? I'm like, man, I think I got him pretty good. Only for them, if they came to trial, it just wasn't that good. Because then they testified, or there's another deposition that the defense took or whatever for trial. Just don't give them a chance to get polished.
Yeah. And I mean, what a tactic. And, these things are scary. And I think we've had now a couple podcasts with guys who have tried cases during COVID. And I know for me, whenever I first started trying cases or was wanting to try cases anyway, I sometimes would give myself some psychological outs. So I would say, well, we're in a pandemic. So, if we go back 8 years and we had a pandemic, say, oh, we have a pandemic, maybe I need to push this case off till next spring. And, my suggestion to people out there who are feeling that way or who are concerned about using some sort of technique or tactic, pick up the phone, give us a call. Chris is a guy. Yeah, right. They'll listen to you. Chris will listen to you. You will listen to you, right?
Yeah. Nakajima will talk all day. Chris Nace will talk all day if you want to talk about trials. They live this stuff.
Right. And if we had all the time in the world, I mean, I've told plenty of people, look, if you want me to come in there and stand with you, sit with you, whatever, I'll be glad to do it. Just get in there and do it. And once you get one or two, or you try something new, it gets easier.
Yeah, absolutely. So it was a good one today.
Yeah, you got it. All right, man. Good talking with you.
Yep. See you.
That concludes another episode of Case Autopsy, the Verdict and Settlement Podcast. Part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.